Testing 1 2 3. Testing 1 2 3.
Good morning, everyone. Our first case up for oral argument this morning is 24-2888 Atlantic Gas Light Company versus Navigators Insurance Company. Good morning.
Good morning, Your Honors.
Mr. Friedman, whenever you're ready.
Thank you. Again, my name is Seth Friedman. I represent Navigators Insurance Company in this dispute. Atlantic Gas Light is not an additional insured because the underlying plaintiffs made their own decision to release USIC, Navigators named insured, and any vicarious liability claims against AGL, and then sue AGL for its sole negligence. Since AGL is not an additional insured, all of AGL's claims fail as a matter of law. This case is a straightforward insurance coverage dispute. The policy provides that AGL is an additional insured only with respect to liability for bodily injury caused in whole or in part by the acts or omissions of Navigators named insured USIC. It is undisputed that the underlying lawsuits seek to impose liability on AGL exclusively for their own acts or omissions in responding to the gas leak.
Mr. Friedman, if I could
Yes.
ask you a question about that particular point.
Absolutely.
The language is liability for bodily injury, property damage,
Yes.
or personal advertising injury caused, right, in whole or in
Yes.
part. So you're saying the subject of caused is liability as opposed to bodily injury?
Yes, the liability, we're looking at the word liability. The liability that AGL has.
Right, but
in the
we're looking
underlying
at,
case.
but we're also looking at cause, right?
Correct.
What cause means. And
Sure.
so it says liability for bodily injury caused.
Sure.
And my question to you is cause can presumably refer, or the subject of cause could be, liability, or it could be bodily injury. I think your interpretation is that the subject of cause should be liability, not bodily injury. Or am I wrong about that?
No, yes, but also I think in this case, if you look at the underlying lawsuits, the bodily injury that they're suing for, the cause of the bodily injury is AGL's sole negligence, and it can only be AGL's sole negligence.
Well, that's assuming that we interpret cause to mean some sort of legal cause, approximate cause, right? If we take the plain word, the plain everyday meaning, if I asked my kids, like, what does cause mean, right? They wouldn't say, oh, it's liability or legally, right, legal cause or proximate cause. And so let me ask you this. If the subject matter of cause is bodily injury, would that pretty much undercut your argument with regard to the interpretation of that particular provision? And if not, why not?
No, I think because it's all controlled by the allegations of the underlying lawsuit. You have to look to what's going on in the underlying lawsuit and the allegations by AGL, by the underlying plaintiffs against AGL and what they're saying caused that. So that's what the bodily injury is for. They're saying AGL caused our bodily injury. Look at that, and that's why in this case the cause, the sole proximate cause for the underlying plaintiff's claims is AGL's sole negligence.
Why do you rely so heavily on the settlement agreement then? Indiana law does
Sure.
say you look to the underlying complaint. And neither side has identified any allegations in the underlying state court complaints that rely on USIC's conduct causation of the bodily injury. Why do we need to go further than that?
I'm fine with that, Your Honor. I think the underlying...
Legally, because you relied, in a lot of your
both.
brief,
Sure.
went well beyond that. You spent a lot of time talking about the settlement agreement, and I share some of the questions that Judge Lee
Sure.
just asked you, because there's a difference in focusing on liability versus causation. But my question to you is, do we even need to go there under Indiana law?
No, because it's controlled by under Indiana law, you can go beyond the pleadings to look for the duty to defend. I recognize that, and that's why we've looked at the settlement agreement, and that also forecloses any possibility that they're being held liable for any actions of USIC, on top of the fact that the underlying lawsuits themselves do not allege any wrongdoing by USIC.
How would it foreclose any liability when the release is focused on liability as opposed to
Sure.
USIC's conduct causing the bodily injury?
Can you say that again, Your Honor?
If there is evidence put in at the state court trial about USIC's conduct potentially causing what's at issue here, even though there's nothing about them being liable, how would the settlement agreement help then?
Because at the end of the day, they can't. What caused it? The only thing they can use, AGL can use it to say, look, you can't try and use anything USIC did against us at the trial. That's what the settlement agreement also says, because there's vicarious liability release as well, and it kind of cuts that off, and it's focusing. All they're worried about in the underlying complaints is AGL's response to the gas leak.
Do you know what the status of the state court action is? Have they?
Everything's been settled, Your Honor.
Okay.
So confidentially,
Yeah, I'm not asking
Yes,
for dollar
yeah.
amount, but everything's been settled.
correct.
All right.
Yes, everything's been settled. So yes, the settlement agreement basically ends up cutting off that liability, and it's really, if you look at the underlying lawsuits, I think Judge Sandy, you hit it, is that it doesn't matter for the underlying lawsuits why the gas line was ruptured at all. It's all about the response, and it is undisputed that is AGL's responsibility.
So the underlying settlement agreement, I understand it's confidential, but not the settlement agreement that we're discussing in the briefs, but the settlement of the underlying state court action. Is there any language in there pointing that would be relevant to this in terms of cause?
Your Honor, I'm not prepared to answer that right now. I can looking it back to you. I haven't looked at those in a long time, Your Honor.
Okay.
So I can, if you want that, we can find that out for you.
Okay.
Mr. Friedman,
Yes.
I think Judge Saney raises a really good point. When I look with regard to the complaint of the underlying cases, and referring to the complaint, I think this is the one by Ogwin, paragraph 20 says that on August 17, 2018, sometime between 9:30 and 10 a.m., a construction crew was boring underground and struck the AGL gas line and a sewer line located on Cortlandt Avenue just east of US 441.
Yes.
Right?
I see that.
So that was the kind of, to some extent, if we putting the proximate cause aside, that was a but-for cause of the damages, right? You agree with that? And I take it you agree with that. That would qualify as a but-for cause, because if they didn't do the boring, then none of the damages would have happened.
I disagree necessarily, Your Honor, because what the real issue in the underlying case is about is if they had responded to the gas leak correctly, this wouldn't have happened. In other words, it's not that that gas line was hit. It's that the response to the gas line and saying everything was fine, they didn't go with the combustible gas detectors. That's what these complaints are about. And so that's really the issue. I'm not going to concede that it's a but-for cause because if...
I thought part of it, sorry to interrupt, but was on not purging the gas lines.
Again, that's
because
also...
they've been there
yes,
for so long and not shutting off the flow of gas, not purging the gas lines.
Yes, there are those allegations. I'm aware of those in there.
Extensive allegations.
Yes,
about
and that's AGL's responsibility, and also, but none of this happens if AGL properly responds to the leak. That's the kind of the main issue in this, because it leaches out from that, goes down there. There's allegations that they say, hey, I smell gas.
I think it's a stretch for you to say that based on the complaints here, that's the focus of the negligence. That may be one piece of the negligence, but the complaints included a lot of additional allegations, including the ones I just mentioned about AGL's alleged negligence.
Yes, it's all AGL's alleged negligence. Yes, correct. I would agree with you, Your Honor. So the only other thing I want to hit on, there was one case we didn't get to our briefing on, and it discovered.
So I'm sorry.
Sorry. Go ahead.
So you're saying that even if the construction crew had not struck the gas line inadvertently or negligently or whatever, that the plaintiffs in the underlying case would still have a cause of action?
No, I'm not saying that.
All right. So I didn't think so. So So I think we can agree then that the construction crew striking the gas line is at least a but-for cause to the lawsuit, to the damages, right? And then I guess from there, the reason why, I guess in the way I kind of look at it, and you can tell me why this might be incorrect, is that the construction crew struck the gas line, and the but-for cause of that was USIC's inability or refusal or failure to identify where the gas line was. And so the way I kind of perceive it is I wonder whether USIC's conduct or misconduct or alleged misconduct was a but-for cause of the damages, because that led to the construction crew, which led to the boring, which led to everything else that kind of took place. And if I read cause to be but-for cause, kind of, and we can argue about whether or not that's the right way to look at it, it would seem that this lawsuit, at least in my mind, would fall squarely within the definition of additional insured. And I'm wondering and I want you to kind of push back against that. I'm giving you this opportunity.
Harsco, the Scott Scale versus Harsco said this language means proximate cause. And the proximate cause of the underlying lawsuit, when you look at it, the proximate cause of the loss is AGL's response to the gas leak. That's the proximate legal cause of the damages they're claiming in the underlying lawsuits, because the underlying plaintiffs made this decision. It's their choice to do this. They chose to release. We didn't force them to do it. No one forced the plaintiffs. They made this freely, willingly, and voluntarily. And so there are consequences to that in all of this. And so they made that decision to release everybody, release USIC and vicarious liability, sue AGL for its sole negligence. Now, there are consequences for insurance, but they went against AGL, and I don't think that was an issue for them, apparently. So, that's where we left it. I think it's proximate cause under Harsco under Indiana law, and that's how the trial judge looked at it. And I think even under Harsco, we're correct. The reasoning under Harsco means we're correct. I think the trial judge incorrectly applied Harsco. I do want to bring up one case.
You are into your rebuttal. Go ahead.
I do. I'm going to save
know.
the rest of the time for my rebuttal, Your Honor.
Okay.
Thank you.
Thank you. Mr. Beckold, good morning.
Good morning, Your Honor. May I begin?
Please.
Thank you. My name is Chris Beckold. I represent the appellees and cross appellants, Atlanta Gas Light Company and Southern Company Gas. With the court's permission, I'd like to refer to those collectively as just AGL. The fundamental problem with the argument from the navigator's side is that it's predicated upon the contention that a company's insured status, as well as the scope of coverage that's available to that company, is to be determined by the allegations in the complaint. But as the court knows from its review of the endorsement at issue in this case, there's no mention of allegations in the complaint, and there's no usage of the word vicarious liability. Rather, as Judge Lee correctly pointed out, the determination is made in terms of cause. Did the named insured cause in whole or in part bodily injury or property damage at issue as a result of its acts or omissions? And in this case, it is undisputed that the named insured USIC failed to mark where this gas line was.
The language you've just cited is from the umbrella policy, referring back to the primary policy, that coverage applies if the conduct caused bodily injury. If USIG's conduct caused bodily injury.
In whole or in part, yes.
But Indiana law does say that an insured's duty to defend attaches based on the allegations in the underlying suit. So it seems to me like you're saying, well, it doesn't matter what the underlying suit says. That's how you determine whether or not the suit is based on USIC causing bodily injury.
Understood, Your Honor, but you have to understand that this particular rupture of the gas line just didn't happen because of some natural disaster.
I know, but would you agree that the underlying lawsuits are really focused on AGL's negligence and not USIC's conduct?
Only because of this settlement agreement and release that was entered into.
For whatever reason, you agree though. You didn't identify anything in your briefing that points to USIG's conduct being alleged in the underlying lawsuits.
That's correct. There was
So
no
those
allegation.
lawsuits really are based on the allegations in the complaint are based on AGL's conduct and alleged negligence.
Correct, because of the settlement agreement and release.
So looking at Indiana law, which says when you determine an insurer's duty to defend under the policy language, that you look at the allegations of the underlying complaint, why doesn't that end our inquiry?
Well, because under Indiana law, you also can look at extrinsic evidence. It's not limited to the four corners of the complaint. And that's exactly what happened in this situation. As I just stated, this is not a situation where we had a natural disaster and all of a sudden we had a gas leak. You know, it was always AGL's position that the proximate cause of this entire accident was the failure to mark where the line was. And, you know, the best evidence of that, I understand the allegations in the complaint, but when you look at what the judgment is, you know, that we're seeking to enforce in this particular case, it's only $13.8 million. And that represents 4 years of prejudgment interest. It represents the 7 figures in defense costs that were incurred, as well as the settlement of these 3 plaintiffs. And if you looked at the liability statements that were attached to our motion for reconsideration, you see how horrific these injuries were. 3 young women.
I don't think anybody disputes that, but that's not the question here. The question is, what does this insurance policy cover in terms of AGL's conduct?
What it covers with respect to AGL's conduct is their tortious conduct. There are endorsements that were available back in 2019 when these policies were issued that could have restricted coverage for additional named insureds. You know, one of them is known as the contractor's extension endorsement. This court may be familiar with from some other cases. In order to have an additional insured status under that endorsement, you have to meet 3 requirements. 1, both the named insured and the additional insured have to have the same claims asserted against them. 2nd, the same law firm has to represent all parties, that is the named insured and the additional insured, and it specifically states that there is no coverage for the wrongful conduct of the additional named insured. None of those restrictions are found in the endorsement at issue in this case.
So what if this case, the underlying case, went to trial against AGL? And if the court during the trial or at the end of the case instructed the jury, you may not find AGL liable based on any conduct by USIC. Is it your position that the policy would still apply?
Yes, because don't forget, the underlying cases were under Georgia law, and Georgia law would have permitted, if the underlying cases had gone to trial, for AGL to show that the proximate cause and the percentage of liability ought to be on the shoulders of...
I'm just saying, what if they were instructed you can't do that, and AGL couldn't bring in any kind of a defense like that? Is it still your position that they would be covered?
Well, yes. And the reason why is because there's no restrictive language in the endorsement. As the trial court correctly pointed out, you know, the determination of coverage under the policy is whether or not the named insured caused in whole or in part the bodily injury at issue.
Why isn't that restrictive, that USIC caused?
Well, it's restrictive in the sense that there has to be some liability on the behalf of USIC, you know, for having caused the bodily injury at issue here. But it's interesting, you know, that you noted that particular endorsement here was first put into effect by ISO back in 2000. And at that point in time, they moved it from arising out of to caused in whole or in part. And as I interpret the phrase caused in whole or in part, it means anything greater than 0. So if in fact USIC is just 1% responsible for the bodily injury, then the endorsement would provide coverage for for AGL with respect to its own tortious conduct. As I just indicated, there were other endorsements that were available that would have prevented that from occurring, but that's not the endorsement that was on this policy. And when you,
I'm sorry, go ahead.
I say, when you look at the cases that have interpreted this particular endorsement, almost universally, all of the courts have held that it provides broad coverage. It's not a situation where it's limited to vicarious liability. In fact, some of the cases, cited in our brief specifically state that it's not limited to vicarious liability claims.
Although a lot of those cases rely on language that says arising from rather than caused by, and there's a distinction there.
Right, and that was the distinction.
That's broader. Arising from
Actually, it's not.
seems broader to me.
I understood, and that was the problem. That's why ISO in 2000 switched it from arising out of to caused in whole or in part, because courts, with all due respect, were putting interpretations on the arising out of that were not with the ISO underwriting intent. And, as I said, I think that the phrase, caused in whole or in part is pretty clear. It's an objective test, and so long as it's greater than zero, then the policy is to provide coverage.
Mr. Buckle, if we could take a step back.
Yeah.
So the Navigators is an excess policy carrier, right?
Correct.
And so the claim was tendered to them for, I take it, for indemnification of defense costs and as well as indemnification of any liability damage to the extent there is any, right?
Well, the Navigator's policy is somewhat like a primary policy in the sense that it provides both defense costs on a supplemental basis as well as indemnity up to the limits of liability, which were $10 million.
Okay.
And so once
I guess my question then goes to, were the lawsuits ever tendered to Navigators for under the obligation to defend?
Yes.
Do they have a duty to defend?
Absolutely. And, contrary to what was cited in the brief of
Well, I mean, the reason I ask it wasn't quite clear from the district court's opinion whether we're dealing with a duty to defend versus duty to indemnify, because obviously, as Judge Saini correctly noted, duty to defend is a bit broader than duty to indemnify, right? And so, and you look at kind of different things. And so, as I was kind of going through the record and through the summary judgment motions, it wasn't quite clear to me what were we talking about. We're talking about duty to defend and a failure to defend, or we're talking about failure to indemnify the cost of defense, which I think are two different things.
So what happened here was at the mediation, the limits of liability of the primary policy were tendered as part of the settlement. So at that point in time, the Navigator's policy attached. And at that point in time, they had a duty both to defend and to indemnify up to their limits of $10 million. And that's what happened after the mediation. When those lawsuits were filed, I tendered the lawsuits of these three plaintiffs over to Navigators for defense and indemnification.
The lawsuits that we're talking about here, not the initial ones that resulted in settlement.
No, correct. Okay. These are the ones that were asserted against AGL.
Against AGL, okay.
And, that's part of the bad faith claim that we asserted, was that rather than making an independent determination as to whether or not the Navigators policy had to provide defense and indemnification, what is it the Navigators did? It goes and solicits from the primary insurer, the named insured, and the named insured's outside counsel a coverage opinion as to whether or not Navigators ought to provide coverage.
You mentioned bad faith. I'd like to move there now while we have a little bit of time left, because Indiana law is not as clear as it could be for us on your bad faith claim.
Right.
Can you tell us, does your claim require us to hold that Navigators owed AGL a duty of good faith before the mediation, or are you arguing that we can find bad faith even if we don't find there is a duty?
Well, I would cite to the court the Philco decision. I think that that's kind of foursquare with the situation that was presented here, where the court stated that when you have a situation where it's clear that the underlying limits are going to be exhausted, the umbrella or excess carrier has a duty of care.
Philco only cited other federal decisions.
Correct.
Do you have anything under Indiana law for us?
No, I don't. But nobody has rejected, as far as I'm aware, at the state court level over in Indiana, the Philco decision. It's been around for a while.
But didn't Philco deal with a lawsuit between the carriers, that is the excess carrier and the primary carrier?
It did.
And it seemed like language the court the relationship the court was focusing on was what duties did the access have with regard to its dealings with the primary carrier. I'm not sure that that would extend to the duties an excess carrier would have to the insured.
Well, I don't think that you can have a higher duty that an excess carrier owes to a primary insurer or a primary insurer to an excess than the duty that's owed to the named insured. I mean, typically on these claims where the excess insurer claims that the primary insurer didn't handle the claim properly, that's the same kind of claim that you would have by the named insured as against the insurer for not handling a claim properly. And quite frankly, I mean, the key point here, as far as AGL is concerned, is that when these liability statements, were submitted back in September of 2019, it was crystal clear that the underlying limits of liability of the Zurich policy, the primary policy, which were only $2 million, were going to be grossly inadequate to deal with the situation that was presented. I won't go through all the liability statements with you, but you can look at them. But just one point, there was $1.2 million that had already been spent on the medical expenses, for these 3 young women. And it was unimaginable that the navigator's policy wasn't going to be, implicated in order to reach a resolution of those claims or to pay a judgment. And what did navigators do? Nothing. Nothing whatsoever. And in fact, that's one of the bases of our bad faith claim, is that from the time of this accident up to the time that I filed this lawsuit, they did nothing. Absolutely nothing to protect AGL's interests, despite, from our position, owing a duty of care to protect AGL no later than September of 2019, when they received the liability statements and understood that there was a $51 million demand, and realizing how terrible this action was.
When, in your mind, when was the aggregate limits of the underlying insurance policies, the primary policies, when were they exhausted?
At the mediation. I mean, all you have to do is look at the denial of coverage letter from Zurich. That was their very first defense. We don't owe you a defense because the underlying limits were paid, as part of the mediation settlement.
And so I take it that under that reading, Navigator didn't owe a duty to defend or to investigate prior to the mediation, because that's when the limits were exhausted.
Correct. They owed a duty of care. I mean, typically when one talks about a defense obligation or an indemnity obligation, it talks about paying money. And we're not contending that Navigators had to pay 1 penny until the underlying limits, were exhausted. But that was the problem. We're at a mediation. We're trying to settle the claim. The Zurich money of $2 million is put on the line. Navigators is nowhere to be seen.
When you say they were exhausted at the mediation, do you mean they were exhausted when you settled at the mediation?
Correct.
Okay.
Correct. And that, from our
So
perspective...
the settlement is what exhausted them.
Right. The settlement was exhausted.
But
Correct.
you're saying they should have been there foreseeing that the Zurich money would have run out very quickly at the settlement, at the mediation.
At a minimum, they should have been available by phone. But given the nature of this particular mediation, they really should have been there. And they didn't even respond to my request that they attend the mediation. I mean, if you look at the record, from the time of the accident, my time's up.
Yes, you can finish answering Judge Jackson's questions.
From the time of the accident until the time that I filed this lawsuit, Navigators had exactly 1 communication with AGL, and that was the denial of coverage letter. And that 1 communication, that wasn't even drafted by Navigators.
Okay.
It was drafted by
Mr.
the outside
Beckle.
counsel.
Yeah, thank you very
Thank you.
much. Mr. Friedman?
Briefly, Your Honors, I want to make sure we got the facts straight on this. The first lawsuits related to any of this were the underlying lawsuits, the 3 women that are at issue in this case. There was no lawsuit at the time of the mediation. And the trial court was correct in holding Navigators had 0 duties, contractual duties, until they exhausted the underlying policy. They talked about duty of care.
And that was at the settlement conference.
That was at the settlement conference, and that's why that's a motion to dismiss that we won those. So I call it the mediation-based claims was on the motion to dismiss, and the court said, even assuming the complaint is true, right? You had no contractual duties, so you don't owe anything. And then we moved to the post-mediation and the lawsuit claims, that are at issue here. And I think the court got it right on all the bad faith and everything there. But the couple of things I want to hit on, on the AI, on the additional insured argument is the facts of this case are certainly unique, right? I haven't found any other cases with these exact facts. Otherwise, we would have cited them to you. I did find one case in going through that wasn't cited in the briefing, but I do want to raise it with you because I think it's instructive. It had some different language, and that's the case of Baltimore Gas and Electric versus Commercial Union Insurance, and that is 688 A2D 496. It's out of Maryland from 1997. Now, it does have a different additional insured endorsement, but what I think is important in that case is, in that case, the named insured and additional insured are both being sued and being defended by the named insured's carrier. And in the middle of the case, the plaintiff dismisses everybody except for the additional insured, everybody. And at that point, the court said, well, the AI is not entitled to coverage anymore because it's only for the sole negligence of the additional insured, and therefore there's no more coverage. So that's just to show it's about the allegations of the complaint, like Judge St. Eve, you've been talking about today, is it's the allegations of the complaint were driving the duty to defend. So our duty to defend is driven by the allegations of that complaint filed in, I think it's December of 2019 and tendered in January of 2020. That's what's driving that, and that's what's driving the liability for bodily injury caused in whole or in part by, it has to be caused in whole in part by the named insured at that point, and it's AGL's sole negligence. The plaintiffs made this decision, right? The plaintiffs made their choice here, and that has consequences. No one made them do it. Navigators was not a part of the settlement. We had nothing to do with it. The record is very clear. He claimed it, there's an affidavit in the record from USIC's counsels that says we had nothing to do with it. We weren't involved, and we were told after the fact. So all of this was just presented to us after the fact, and I think that's is proper if you look at the allegation of the underlying complaint. It's solely as to AGL. I see I'm running out of time, and if you have any other questions, I'm happy to answer them.
Thank you, Mr. Friedman.
Thank
The court
you.
will take the case under advisement. The next case for oral argument this morning is 25-1034, Soud versus DePaul University. Good morning, Ms. Abraham.
Good morning. May it please the court? My name is Christina
Wait,
Abraham.
1 second. We'll just let counsel get situated there. Sorry, Miss.
Absolutely.
We'll put your 15 minutes back, yeah. Okay, go ahead, Ms. Abraham. Sorry about that.
No worries. May it please the court? I am Christina Abraham. I represent the plaintiff, late Saud, in the matter before the court today. The case is governed by simple logic. The necessary condition for trial is the presence of genuine disputes of material fact. The sufficient condition is that those disputes, if viewed in Mr. Saud's favor, could allow a reasonable jury to find discrimination. Both conditions are satisfied many times over. The district court's grant of summary judgment was error. The record contains multiple independent disputes of material fact. Any one defeats summary judgment, and together they overwhelm it. The first dispute is contradictory testimony about the reason for non-rehire. DePaul now claims that Chair Kesh refused to rehire Saud because of the CM allegations and because of so-called other complaints. But at the CM trial, Kesh swore under oath that the decision was the dean's and that it had nothing to do with CM's allegations. He also swore he had never heard of any other complaints regarding Saud. Today, DePaul says the opposite. That is a direct contradiction on a material fact. The second dispute are the other complaints. These so-called complaints were vague hearsay, never documented, never investigated, never reported contemporaneously. Investigator Tamburo herself noted there was nothing to investigate. Yet the district court credited DePaul's position that Kesh believed them, even though Kesh testified in 2019, 2 years after the fact, that he knew of no such complaints. That is a classic credibility dispute. The third dispute is the chronology problem. Kesh canceled Saud's courses in May, 6 weeks before Martalogu filed her lawsuit, CM filed her lawsuit, and or any other so-called complaint surfaced, again contradicting DePaul's claim. DePaul cannot rely on later events to justify an earlier decision. Chronologically, it is impossible. The fourth dispute are misrepresentations about course cancellations and salary. Keshk told Saud that he canceled both his and comparator Lysic's classes. In truth, he only canceled Saud's while he was in good standing. Keshk testified that Saud was a popular professor whose classes were so full they often had wait lists to enroll. By canceling his classes, Keshk prevented students from enrolling in Saud's courses, thus suppressing enrollment and opening the low enrollment pretext claim later. Keshk told Saud he was not rehired because he had asked for too much money, but comparator Lysic, a white colleague, asked for more, had his request forwarded to the dean, and he was retained even though his request for more money wasn't granted.
You've relied on Lysic as a comparator, but the investigation that was done of Lysic they determined that there was no wrongdoing there, that it wasn't even the right person, that these comments that were made about a professor, they linked them to somebody else. So how can Lysic be an appropriate comparator for you when the investigation here, DePaul determined that your client had sex with the student when she was in his class?
So there are two ways I would respond to that. First, in the case of Lysic, there was no determination that was made. They couldn't communicate with the accuser. Lysic's accuser accused him of rape, and they were never able to identify.
But they determined that it was not Lysic. They did not have sufficient evidence to determine that this was Lysic who was being talked about.
There was no determination made. It was Lysic who said that, who raised that as his defense. There was no investigation conducted.
But there was no finding of misconduct on his part when there was a finding of misconduct on your client's part. So how can he be a comparator then?
Exactly, because the two were in similar situations. Both had been accused of misconduct, and both were treated differently. And that's what the comparator analysis looks at. Are these two substantially
the comparator analysis, under our case law, it has to be apples for apples. It has to be a very clear, appropriate comparator.
But we don't require clones. We require substantial similarity. And here you have two people in the same department, teaching at the same level, who were accused of similar misconduct. You have the
but you don't have a student from DePaul coming forth against Lysic saying...
You didn't have one in Saud's case either. You had a
CM.
letter. You had CM who never cooperated with Title IX.
But she's a student there, and she made the complaint.
So presumably was the person who accused Lysic, but they never even tried to find him, the person who accused Lysic. They just took Lysic's
I don't think that's
defense.
what the evidence bears out here, but go ahead.
I'm sorry, can you repeat what
I
you
don't
said?
think that's what the evidence in the record bears out as to
The evidence in
Lysic.
the record, according to Schaefer, who was deposed in this, and she conducted that investigation, she did nothing but receive Lysic, talk to Lysic, and she received his explanation. And he said, "This isn't me."
If we don't think that you have identified appropriate comparators, can you still prevail?
Yes, we have other evidence that we could rely on, but I would say Lysic is an appropriate comparator. Lysic was accused of rape. Schaefer talked to him. Lysic was the one that said, "It wasn't me, it's probably mistaken identity." But the accuser actually named him by name, by department, and by school. Lysic said, "Oh, this is another professor at a different school that teaches rape studies." But the accuser actually named Lysic by department and by university. So, and they took Lysic's statements and they credited them, and they never spoke to an accuser in that case, and they never really did a thorough investigation, which is corroborated by investigator Cheryl Wayne's testimony, where she says we don't conduct investigations if we don't have the cooperation of the accuser. And that is the substantial
But the
similarity.
allegations against Lysic, as I recall the record, were made on social media, right?
Yeah, but I think that's a distinction without a difference. There's an accusation made.
Well, you think
in
it
both-
doesn't? Hold on. You think it doesn't matter if as far as kind of the university goes, whether an allegation is made anonymously on social media versus where a student formally files a complaint with the university?
The student did not formally file a complaint. The university received a letter from her attorney. The student did not cooperate with the investigation. The student refused on 2 occasions
And you
to
think
cooperate.
you think that those situations are similar enough to pass the comparator's test.
I do,
in our
especially when you consider Wayne's testimony, where she talked about the process. And she said, we do not investigate if we don't have both sides to talk to. Otherwise, there's an inherent appearance of unfairness there. And that's their process, and they deviated from that process in Saud's case.
So, you know, I guess the way I see it, there seems to be kind of two adverse employment actions that your client is challenging. One is the decision not to hire him as an adjunct instructor in the fall of 2017, where, you know, like that initial letter from Cash. And the second is the letter saying that DePaul will no longer consider him for any future jobs, right? With regard to the first letter, after that first letter was sent, at least the record seems to indicate that Cash was trying to get more money for your client and kind of working with your client to try to schedule classes. And Tumburo cleared your client of the first, you know, with regard to the first Title IX inquiry. And so it's, from that vantage point, it's difficult to see how that conduct would be consistent with a university's motivation to either terminate him or to treat him badly because of his race. And I'm wondering if you can kind of tell me how you view those facts about the university and people and Cash coming to Saud's assistance during that time after that initial letter.
Nobody came to Saud's assistance during that time. So the first thing
Well,
I would point out
I
is
guess,
that
you know, you say that the second letter, the second Title IX inquiry, where, you know, they took him to task, different from the first inquiry, that was motivated by race discrimination. And I wonder if they were going to discriminate him on the basis of his race, and wouldn't they do that the first time too? Like, I'm trying to understand, like, you know, in the beginning, there seems to be, you know, looking at the facts, kind of record as a whole, there seems to be, you know, efforts made by the university on your client's behalf. And I'm wondering how, or at least, you know, purportedly on your client's behalf. And I'm wondering how you view those facts.
the way that we view them is that when Saud was cleared in May and he began discussions to come back to teach as an adjunct, just at the same time LISIC was, LISIC's courses were assigned to him for the fall. They were posted and they were assigned to LISIC. In Saud's case, his courses were assigned to staff. And with Keshk knowing that there were regularly wait lists for students to enroll in Saud's courses, he knew that that was going to suppress enrollment in his courses. Thus, that would create the pretext for low enrollment later. Also, we see that he invited Saud to request enhanced pay along with LISIC, but did not forward Saud's request to the dean. He forwarded LISIC's. LISIC's was denied, but he was offered the base rate. Saud was told he asked for too much money. This disparity in treatment shows us that the steps they were taking with respect to Saud were pretext. They were just there to create the excuses.
What would have precipitated that timeline? As I read your briefs, you start everything with a Campus Watch article.
Yes.
And from there you say Kesh treated Saud differently.
Yes.
In the cancellation of his classes. Is
Yes.
there anything else there that I'm missing in your timeline about what would have motivated Kesh to treat Saud differently on the basis of his race?
We have from the affidavit of Scott Pace that the pattern was that if a professor was outed on Campus Watch or one of those watch list websites, that Title IX reports would very soon follow. That happened to Pace.
I didn't see a lot of information in your briefing about this Campus Watch article. And it seems as if Saud participated. He was interviewed.
No. He was interviewed in another article for another publication, and then Campus Watch wrote an article about that.
Okay.
And they published
Have
it.
you told us in this record, was that Campus Watch article a hit piece? What information do we have in the article so that we can draw the inferences you want us to draw from that article as something that motivated Kesh
The point
to
is-
treat Saud differently?
Yeah, the point is that Campus Watch itself, when it publishes anything about a professor, it's putting them on a target list. And Keshk acknowledges that in his deposition. He's aware of what Campus Watch is and what it does.
Does it matter that article that you're discussing with Judge Jackson and Kumi really focused on Saud's speech and not his race?
I think it's irrelevant because Campus Watch, if you go to the website, they do talk about.
But
and
wouldn't
they
that
target
be
Middle
relevant
Eastern-
to a race discrimination claim? If your argument is that putting on Campus Watch, that started the ball rolling, and if Campus Watch is all about his speech and what he was saying on campus that others may not have agreed with, and that's what got the ball rolling, how do you make the connection to
It
racial
may have gotten the
discrimination?
ball rolling, but it doesn't justify what DePaul did and how they treated him differently from other people on the basis of his race. So we have also to that Kesh told Saud that DePaul would discriminate against him, right when Saud told him about what was going on with the Title IX complaints. And I also want to point out that
You
DePaul
are in your
invented-
rebuttal time, just so you know.
I know. I want to make just like one more point before I rest for rebuttal. They invented policy violation. DePaul claims that Saud violated policy on faculty-student relationships, but DePaul doesn't have a policy prohibiting such relationships. Coordinator Tamburo acknowledged this, as did the OIDE VP, and Cheryl Wayne corroborated this as well. So whether this policy existed at all is flatly disputed by DePaul's own officials. And there were the Title IX irregularities. The fact that Tamburo denied and deprived Saud of a counterclaim, where with the white comparator Joseph Sulia, she proactively gave him that right. We talked about the comparators and then the discriminatory animus. I would add to that Almina McLeod, an African-American senior faculty member, provided an affidavit confirming that Kesh regularly suppressed and ignored concerns raised by minority faculty. These conditions, the necessary conditions, are met. The sufficient conditions ask whether, taken together, a jury could find discrimination, and I think overwhelmingly they can. I will reserve the rest of my time for
Okay,
rebuttal.
thank you.
Thank you.
Mr. Paul?
I'm ready when you are.
Whenever you're ready, go ahead, please.
Thank you, Your Honor. May it please the court. Brian Paul on behalf of defendant appellee DePaul University. In Naka v. McAllister College, the District Court of Minnesota summed up this case quite accurately, though writing about its own. There, the District Court wrote, quote, "Nothing about the circumstances of this case gives rise to an inference of discrimination. What changed after May 2015 was not the plaintiff's race, ancestry, sex, sexual orientation, or religion. What changed is that a former student made a formal complaint of sexual misconduct."
Let me ask you about that timeline then. Saud's courses were canceled in May before CM's allegations came to light. Why were all three of his courses canceled at that time, but only one of Lysak's canceled courses?
Well, this goes back for a moment. In April of 2017, for budget reasons, both Mr. Lysak and Mr. Saud were, their employment was ended due to budgetary concerns. That's not an issue in this case.
We understand that.
Right. So what happens after that? The courses aren't canceled. Staff is listed for Saud. Lysak has one case that remains on. What complicates that, as they're trying to figure out how to list for that case, is the first Title IX investigation. So as they're doing the first Title IX investigation,
No, but the relisting, as I understand it, happened before the CM allegations came to light, before the attorney lien letter.
the relisting of his courses occurred after the first determination by Karen Tamburo in May of 2017.
No, the initial taking them off the schedule, that happens before.
That happens.
And all three of his are taken off and only one of Lysak's. I think you're skipping ahead to where they're put back on.
They're removed as term professors because neither one are term professors anymore. It is true that in that process, one of Mr. Lysak's courses managed to slip through as a continued term, but that was changed and corrected to adjunct.
So that's the moment I'm talking about. Why the difference in treatment?
That's not a difference in treatment. That's just as they're doing through their internal system as to how to list these courses and what to name. There's just they don't get to one of Lysig's courses until later when they have to change his status. They remove 2 of them and not the 3rd.
So you're saying that was just a mistake?
That's just I don't even know if it's a mistake as much as it is they're going through their process internally of
Did I
electronic
miss the
listing.
deposition testimony about that?
Uh,
About all 3 of Saud's being removed, only one of Lysig's, and that being an administrative mistake, and all of Lysig should have also been removed. Did I miss that?
Well, removed, it should have been changed to potentially an adjunct professor and not the term professor, and that change did ultimately happen. That is, I believe, Kesk testifies to that, but I don't remember explicitly which deposition testimony that comes from.
So at some point, that other Lysig course was changed as well?
Correct.
To staff?
Well, to adjunct. So he moved from a term professor to an adjunct.
But it was never listed as staff, the same as.
I am not aware of it having been listed as staff. I don't believe there's record evidence one way or the other on that. Here, in this case, like in McAllister, plaintiff appellant Laith Saud pursued and initiated a sexual relationship with a student in his class. As a result of that decision, Kesk made the decision not to hire Mr. Saud again in the fall of 2017 to teach a quarter, and after DePaul finished its 2nd investigation, the dean made the decision that Mr. Saud would no longer be eligible.
Why didn't he just tell him that? Why didn't Kesk just tell Saud that he couldn't be an adjunct because of the lawsuit?
Well, you have to put yourself in Kesk's shoes in that moment, right? The timeline here is very important. On June 28th, he writes to Saud and says, and to Lysig, and says, "Tell me what your salary demands are. I will go see if what I can make happen on those." On June 29th, CM files her lawsuit, and a Sun-Times article is also published. On June 30th, Kesk learns of the lawsuit. Then, over the July 4th holiday, he has 2 more people come to him. There's a pending lawsuit. It's got DePaul's name in it. Kesk doesn't know what he can or cannot say about that lawsuit. What he does know is that given that lawsuit, he's not going to negotiate salary and he's not going to work on the course load. So he's clear in his testimony on that. Counsel would have you believe there's contradictory testimony from the trial of CM in 2019. There is not contradictory testimony. Kesk is asked at that trial 2 things. 1, why was Saud's employment ended? He testifies, because of the budget cuts, that decision was made by the dean. At no point during that trial do they say, is there a reason he was not rehired as an adjunct? That question is not asked. Second, there's a suggestion that Kesk testified at trial that he was not aware of any complaints. The question actually is, during the 12 years you taught with him, did anyone make you aware of a complaint? All the complaints about Saud came after he had stopped teaching, and indeed, the complaints that caused the decision not to rehire occurred after Mr. Saud was no longer employed at DePaul. The timeline here is very important. June 28th, Dr. Kesk is working hard to try to find a spot for Saud. Lawsuit filed the next day. Kesk learns of it the next day. 2 more complaints over the next 4 days. Then a decision is made. Saud's race is the same before June 28th as it is on July 6th. The only thing that changes, just as in McAllister, is the lawsuit that comes in. And it's a lawsuit that alleges he used his position as a professor to coerce a non-consensual sexual relationship with a student. The Seventh Circuit addresses this in CS, which dealt with whether or not a school should put a teacher in a classroom while there are allegations of harassment. In that case, the Seventh Circuit instructs a school that knowingly employs a serial harasser is asking for trouble. On the legal side, the litigation process, discovery and summary judgment, will allow everything to get sorted out after the fact. But as a practical matter, when the school officials have to make decision in real time, the best course will be to err on the side of taking reactive and preventive measures. That's exactly what Kesk did. He was faced with a difficult situation, who, by the way, Kesk is also Middle Eastern. He's taught with this person for 12 years, but he's staring down the barrel of serious allegations. He cannot put him in the classroom that next quarter. It's nothing to do with his race, and it has nothing to do with the Campus Watch article.
Is there any evidence that after the lawsuit was filed that Mr. Saud denied the allegations to DePaul? I know he sent the answer in response, and the answer didn't outright deny them. Is there any evidence that he denied them, the allegations?
The only thing he submitted, Your Honor, was his verified answer. That verified answer did a couple important things for Ms. Tamburo. Number one, that verified answer admitted that while CM was a student in his class, they went out for drinks after class and their relationship became flirty. Importantly, in the affirmative defense labeled consent, Mr. Saud pleads some very specific facts. He pleads that he did not make their sexual relationship contingent on giving her an A in the class. He did not make her sexual relationship contingent on any performance or grading in the class. What's implicit in that is that that sexual relationship occurred during the class. Had it occurred not during the class, he would have simply said, none of those things are possible because we didn't have sex until after she was no longer a student. Using a preponderance of the evidence, Karen Tamburo took that evidence, changed her finding, and determined that, in fact, Mr. Saud had sex with CM while she was a student in his class. It turns out that could have been wrong or could have been right, and it wouldn't have affected this case because DePaul acted on that belief. It turns out, we now know she was right. Her second investigation got it right. Her preponderance of evidence finding was correct. And in fact, he did have sex with a student in his class. Mr. Saud can disagree with whether DePaul should have taken the action all Mr. Saud wants. He can say he should have been free to have a sex with a student in his class. What he has not done in this case is show that had he been of a different race, DePaul would have made different decisions. We heard a lot of talk a moment ago about Mr. Lysick and whether or not he's a comparator. As this panel has properly observed, there was an anonymous Facebook social media post that was reported by someone else to the university. Contrary to contention by counsel, DePaul did investigate it. In fact, DePaul took the photo that was on the social media post and tried to match it to a student. No one could match it. They talked to Mr. Lysick. In direct contrast with Saud, who said, yes, I did sleep with the student, Lysick said, I don't even know who this student is or what they're talking about, and by the way, my name's not spelled right. If you want to find the person who's spelled this way, who also happens to be a professor dealing with rape as a topic, here he is. Based on that, DePaul found that there was no misconduct. As the panel's already...
You can understand why Mr. Saud is not mollified by that, because the allegation on Facebook did say a DePaul Catholic studies professor, it may have been religious studies. So even if the name was misspelled, it clearly identified this person as teaching in DePaul's religious studies department. So as I hear Ms. Abraham this morning, she's pointing to a difference in investigation, not so much a difference in outcome, but a difference in investigation. Can you speak to that?
Yes, I can, absolutely. There is no difference in investigation. Let's assume that both complaints are the same for a moment, which is absolutely not true, but let's assume that they are. What happens as a result of the complaint? They go speak to the alleged harasser in the case, one being Lysick, one being Mr. Saud. In the first instance with Mr. Lysick, they speak to the harasser, they interview him, and they try to identify the student. They can't identify the student, probably because the student doesn't exist, but put that aside for a moment. We don't have a name, it's Donnie Wan, who isn't, they check, there are no Donnie Wan students. They use the photo, they can't find it. What else is DePaul supposed to do in that situation to further investigate when Lysick denies knowing anything about it? In contrast, when they get CM's first letter from the lawyer, they're able to identify the student, they know who it is. They go to Mr. Saud and they interview him. In fact, they take him at his word. And in their first investigation, they find no violation because Mr. Saud represents that it happened after his course, and in fact, it was his understanding that she was no longer enrolled in DePaul when they had a sexual relationship. The investigations are the exact same. The facts that come out are drastically different. And then what happens, so still, first investigation, same race, same ethnicity, no violation. Second investigation, we now have a verified answer that I already spoke to Judge St. Eve about that's indicated why there was a sexual relationship while she was a student in his class. Based on that preponderance of an evidence, they find violation. The investigation process is the same. The outcomes are drastically different based on different facts. Lysick is not comparable because DePaul never determined that he engaged in any misconduct whatsoever.
Mr. Paul, going back a bit to Mr. Kesh's testimony during the trial, so what you're saying is, he's asked, to your knowledge, the decision for Mr. Saud not to be retained by DePaul have anything to do with the allegations made by CM? And Mr. Kesh answers no. To my knowledge, no. So what he's talking about there, about when Saud's not being retained, was that initial letter when there were when his status as adjunct was terminated.
When his status as a term professor was terminated as of April 2017. So you
not later on when DePaul said, we're not going to rehire you ever.
Correct. You can see in the questioning of the testimony, why was he not retained? Budgetary reasons, a decision by the dean. And that is accurate. He was not, that was the end of his employment at DePaul. The other stuff is just whether he will ever be rehired. I don't have a rebuttal, so I won't save my 45 seconds, but if there are any other questions, I'm happy to answer those.
Thank you.
Thank you, Your Honors.
Ms. Abraham, you have 46 seconds left.
The first thing I will point out is that the cases pointed to by DePaul in those schools prohibited relationships between faculty and students, and DePaul does not. Kesh was asked about this at the CM trial. He first did evasively respond, but then he was asked point blank by opposing counsel, by Martalogu's counsel, was the decision for Mr. Saud not to be retained by DePaul have anything to do with the allegations made by CM? He said, to my knowledge, no. This has to go to a jury. These inconsistent sworn statements create pretext, create triable issues of facts. The other thing I wanted to point out was Lysick and Saud as term faculty had 3 courses. Lysick's 1 course was canceled, 2 were reserved for him because adjuncts only teach 2 courses per quarter. They don't teach 3. That's why. Lysick's courses were assigned to him, Saud's were not. This case should go to trial. We ask the court that reverse the district court summary judgment grant.
Thank you, Ms. Abraham. The court will take the case under advisement. And our next case this morning for oral argument is United States versus Bridges, appeal number 24-2652.
Good morning. May it
Mr.
please
Tice.
the court. Bill Tice for Mr. Bridges. This case involves a sentencing guideline that doesn't really come up very often. The district court judge had a very specific job to perform, and that was to find beyond a reasonable doubt that Mr. Bridges was guilty of 2 separate conspiracies, and from that flowed various sentencing enhancements. We know that the judge was aware of his duty because it seems like he was the one who really brought up the case, and both sides were kind of not really too aware of it. And he did, of course, impose the enhancements, but his explanation for how he got there leaves a lot to be desired.
Mr. Tice, could I just clarify something, please, about your argument? Is your argument that the district court didn't make the finding it needed to, or that the district court found that your client had conspired to commit both robberies but didn't explain that finding?
It's the latter. He made that finding because otherwise he couldn't have imposed those enhancements, and he didn't explain it properly. As far as we can tell from the record, he focused in on the fact that Bridges had been present in these two meetings. Now, it's also sort of lurking beneath the surface, and the government brings this out, that he seemingly relied on the fact that Bridges was seen running out of the stores on both occasions. So those are two things: attendance at the meetings, running out the store, and that's really all that the judge had.
Well, he also observed the trial, right? I mean, he obviously saw all the evidence come in and the testimony come in, and so he had that as far as kind of all the facts that were before him.
Yes, and that makes this case sort of unusual in another respect, that, you know, it's not just a PSR or a guilty plea, it's a trial, but yet there's no explanation of how those things come into play. What did he hear at the trial other than, and he points to, the client attended the meetings?
Would harmless error apply here? Because as Judge Lee notes, the judge presided over the trial. If there was sufficient evidence in the record that came out during the trial that would support the court's finding, can we apply a harmless error analysis?
I don't think so, and I want to be quick to note that the government has never raised harmless error.
I understand. I'm going to ask them the same question, but
And I think this court should be really leery of taking up something that the government hasn't raised and hence hasn't been briefed. Now, they come sort of close to harmless error in saying there's sufficient evidence in the record to support those findings, but that once again is looking at the wrong issue.
Is harmless error something we can apply at a guideline calculation determination?
Oh, this court, I think, routinely applies harmless error in guideline calculations. But the normal course of events is that the government raised it. And it sort of defies imagination that the government, in briefing this case, sort of didn't really think, oh, should we raise harmless error?
Well, although we do have cases where we've gone to harmless error even where the government didn't raise it. So with that, what is your case for why the error was not harmless here?
It's not harmless here because we really don't know what the judge was thinking, and so, you know, the government, of course, has got the burden on harmless error, and what they've got to be able to show to you, if you want to go down that path, is that if despite the fact that the judge didn't explore his reasoning, he just had to find that Bridges conspired as to both of these robberies. And that really requires a lot of mental gymnastics. Now, the three of you here today, maybe, I don't know, I can't read your minds, maybe you feel like you would have convicted Bridges of either one or both of these robberies, or conspiring to commit both of these robberies. But that's not really the same as saying Judge Johnston inevitably had to have come to that result, even though he didn't tell us how he would get to that result.
So how much explanation do you think should be required of district judges in a situation like this? From your briefs, I kind of inferred that it would be something less than what Rule 52 would require for a bench trial, because this is in terms of sentencing, unless I'm putting words in your mouth. It seems like Rule 52 wouldn't necessarily apply. And in the context of sentencing, we have held in lots of cases that where a judge makes a finding, the explanation of that finding need not be, completely satisfactory to everyone in the courthouse. And so I'm wondering what sort of rule you would like us to articulate with regard to how much explanation a district judge needs to give in this particular circumstance.
Well, I don't think anyone could ever give you some sort of one-size-fits-all for this. But
part of our job is to kind of instruct the district courts on like what they should do next, right?
I think there are things you can say in this opinion that will alert district judges as to what they should do and certainly what they should not do. And if the district judge is going to set up facts in support of the conclusion, if those facts are based on errors of law, that's not a good explanation. Saying, oh, he attended a meeting and ignoring what he agreed to at the meeting, that's not good enough.
Would that be an error of law or an error of fact? It sounds like a factual error you're talking about.
Well, it's an error in not... The fact is he attended the meeting, and then we have the conclusion, the judge's conclusion, therefore he conspired. That depends on a misapplication of the law. It is not the law that someone who attends a meeting is guilty of conspiracy. So
we've held with other guidelines that a judge can make implicit findings and they would suffice.
That's true.
Why wouldn't that apply here?
It doesn't apply here because the implicit finding is if you attend a meeting, you've conspired. That's the rub. And one thing I don't want to lose sight of a couple things that I know I'm getting close to rebuttal. 99% of the cases you see involve cases where the judge is deciding matters as a preponderance of the evidence. This is really so different. And the other thing that's unusual about this case, and I think would give guidance to judges in the future, although it's probably stuff that's not going to come up again, there were two very unusual facts in this case that any responsible fact finder would want to take note of. Bridges had tried to plead guilty and told the judge, I went there because I wanted to see what my girlfriend was doing. The judge didn't say, oh, that's a load of whatever. The judge said, wait a second, you can't plead guilty because I'm hearing things that are inconsistent with your guilt. And the jury acquitted him of those. And
although the judge couldn't have commented on that during a Rule 11 plea colloquy, because otherwise you'd say the judge was interfering with it, to be fair.
Right, but the judge could say in his mind, I don't really go for that, but the judge did the responsible thing and said, you're telling me facts that are I can't take the plea. We know what the defendant said at the attempted plea. We know what the judge did. And yet, in making the findings at the sentencing, there's no mention of that. And the other, I think I want to save the 51 seconds for rebuttal.
Okay.
I think I've made my point. Thank you.
Thank you, Mr. Tice. Ms. Altbeth, good morning.
Good morning. May it please the court, Haley Altabeth on behalf of the United States. The district court did not commit procedural error in resolving the parties' dispute regarding guideline 1B1.2D. At sentencing, the district court made findings showing that the defendant conspired to rob both the Best Buy and Simply Mac stores. In the sentencing transcript, the district court specifically found that the defendant physically met up with the co-conspirators before each robbery, that the defendant traveled to the robbery site in a caravan with the other co-conspirators in each robbery, and that after the robberies, the defendant fled with the robbery crew back toward the same vehicles that they had used to get to the robbery site. In addition to that, the district court adopted the PSR, which included more factual findings regarding...
Does it matter? I think the district court adopted the PSR after the guideline determination. Does that matter?
I don't believe it does in this instance for this guideline application, as the district court adopted all of the facts relevant to relevant to the conspiracy count.
Where do you see where the district court expressly held that Bridges conspired to commit each of these robberies? Because what strikes me is he goes off into a tangent about the meetings. He says, I can't remember from trial how many meetings, and can anybody help me? And the lawyers don't really help him. And then from there, he says, I find I make the finding.
Yes.
So tell me, where's the express findings that you say you see there, the express explanation?
So the express explanations regarding those findings I just listed are on the appellate record at A25 and A26. Those do precede his ultimate finding that section 1B1.2D applies. But regarding his application of that, I think it's fairly clear because we're only talking about
But he says, I
two
can't
robberies.
recall if that testimony about the meetings was for both robberies or just one. And I don't see him circling back to say, okay, I've decided that the meeting I recall from trial was about this robbery or that robbery or both robberies.
Your Honor, if we look at the record on A26, I believe, and later on A25. So on A25 towards the bottom of the page.
Can you tell me what page of the transcript that is?
17.
17, thank you. Looking at line 18, the court says, but you are correct. They had to have met up somewhere because they all went in one or two of vehicles to the location. So they had to physically meet up somewhere.
Which robbery is he talking about?
In that instance, he is talking about both. In the sentence preceding it, he said, I read that to mean that he is speaking about both robberies.
Even though the sentence before says he can't recall if the testimony related to both robberies or just one.
I read the next sentence saying, but you are correct that they had to have met up prior to both robberies because he recalled that he went in one or two vehicles with the co-conspirators to both of the robberies.
But then he goes on, the defense counsel speaks up after that and says, my recollection is that the testimony was contradictory. And the court says, okay, yes, all right. But yes, she did testify that she drove him there. And I have a very vivid memory of the video of the parking lot. So again, it's hard to tell which robbery the court is talking about.
It is not I would say it's not a model of clarity on those two pages, but I do think that because we know there are only two robberies here, and the ultimate result is that the district court applies the guideline and says that he's applying the guideline for obviously both of those conspiracies. There's no question about which robberies we're discussing.
Is that sufficient for beyond a reasonable doubt? I think that's my big hesitation here, that it is not a model of clarity. And the court itself seemed confused about what the evidence supported. And we've made clear for this particular guideline, the court has to make that determination beyond a reasonable doubt. Why would this satisfy that standard?
I believe it satisfies the standard because there are no magic words that have to come through, and the court does allow implicit findings. Implicit here within this, within the sentencing transcript, is that the defendant agreed to rob both of the stores. I also think that by incorporating the PSR, which contains more detailed findings about each of the robberies and defendant's participation in them, there's certainly sufficient information here in order to conclude that the defendant conspired to commit both.
Is that responsive to Judge Saini's question about the standard of review, though? When our holdings about implicit findings and the leniency that we afford sentencing explanations, that's all when it's preponderance of the evidence.
My understanding is that's correct. I do not know of a standard that is different in applying to this specific application note, which requires a beyond a reasonable doubt. But what the record does make clear is that the district court knew exactly what the standard was. I believe that, as even defense counsel pointed out, it was the district court that led off the discussion about there needing to be a beyond a reasonable doubt finding here.
It's hard to find any support in the case law because so few guideline calculations require the beyond a reasonable doubt finding. So there really isn't much case law out there. And in JET, we made clear the beyond a reasonable doubt has to apply, but we didn't address some of these other issues.
Yes, and I think that a lot of these issues can be sort of buttressed by the findings in the PSR. The PSR
But the
states
problem with about adopting the findings of PSR is that we don't know what standard the probation office applied in coming to its recommendations. Presumably, I would think that they applied preponderance standard. And then when district judges, typically adopt the PSR, in their mind at least, they have the preponderance standard, right? Because that's kind of what applies to in most situations. Here, I guess it would have been helpful if the judge had said, you know what, I adopt the statements and the factual findings in the PSR because I believe that those can be established beyond a reasonable doubt, but he didn't do that. And so I'm troubled by the reliance upon the judge, the government's reliance upon the judge adopting the facts of the PSR in kind of that context of where it's not completely coherent as to what standards were applied in adopting those facts. Is there a way is there an avenue by which the district judge's decision, the sentence can be affirmed, putting aside his reliance on the PSR, or do you think that reliance on the PSR is central or a necessary component of the house that you're trying to build?
I don't think the PSR is necessary. I think it is certainly helpful. And I think that because the district court knew that it was adopting those facts within the context of beyond a reasonable doubt, it's fair to infer that it knew that those facts that are in the PSR, it was adopting beyond a reasonable doubt. But I think the big difference here, even setting aside the PSR, is that this is the district court judge who sat through the entire trial. This district court judge sat through the testimony of 3 co-conspirators who got up and said that the defendant was a member of their conspiracy and that he conspired with them to commit both of these robberies, and that testified that he was at both robberies. That was all corroborated by video evidence as well.
This leads me to a final question from me, at least. Have you waived harmless error analysis?
I don't believe that harmless error analysis applies here. If this is truly an issue of procedural error and the procedure is failure to explain, I don't think that the failure to explain is subject to harmless error. I think the proper process would be for this to go back down to the district court and for there to be proper explanation. Unless there are any further questions, I ask that you affirm the decision of the district court.
Thank you.
Thanks.
Mr. Tice.
I have a brief comment about the PSR, although it's a little unclear to what extent the government relies on it. The PSR very explicitly states that the writer is relying on the indictment and the government's version of the offense. And even more importantly, in paragraph 56 of the PSR, the writer says, pursuant to USSG 1B 1.2D, which is, of course, the guideline, a conviction on account of charging a conspiracy to commit more than one offense shall be treated as if the defendant had been convicted on a separate count of conspiracy for each offense that the defendant conspired to commit. It's clear from that language that the PSR writer is not really thinking about the knotty issues that bring us here today. So the PSR is not going to resolve this. The key, of course, is what we looked at on page 17 of the transcript, where the judge is saying, I don't have any recollection. And so, thank you very much.
Thank you, Mr. Tice. The court will take the case under advisement. Thanks to both counsel. And Mr. Tice, I understand you were appointed to represent your client. Thank you on behalf of the court for your strong advocacy on behalf of your client.
Thank you.
We are going to take about a 10-minute break and then we'll pick up. Our next case for oral argument is appeal number 25-1746, United States versus Cohen. Good morning, Mr. Pickar.
Good morning. May I proceed?
Please.
Thank you, Your Honors, and may it please the Court. Josh Pickar on behalf of defendant appellant James Cohen. The United States sentencing guidelines are clear about what information courts can consider during sentencing. Strict adherence to those parameters is necessary to further the Sentencing Commission and Congress's goals of uniformity and foreseeability in sentencing. In selecting a Chapter 2 offense guideline, courts may only consider the charging documents. This court should vacate Mr. Cohen's sentence and remand for resentencing under the guideline for fraud and deceit because the information did not show that Mr. Cohen's false statement related to sex offenses, and the information did not provide sufficient facts to support application of the 8-year enhancement, both of which are required for application of the obstruction of justice offense guideline. Turning to my first argument, failure to register under Section 2250 is not a sex offense. The Sex Offender Registry and Notification Act is explicit that failure to register is not a sex offense, and multiple other provisions of the guidelines that were passed concurrently with 2J1.2 and after the fact are all clear that failure to register is not a sex offense.
It may not be there, but Appendix A specifically provides that the statutory max applies to sex offenses under 109B. And if you look at 109B, it talks about failure to register. It's the only provision there. Wouldn't your argument just do away with 109B?
No, Your Honor.
How do you make sense of that?
Sure. 109B only has one statute, 2250, but it has multiple criminal prohibitions within that statute. So A and B speak to failure to register, and then subsection D speaks to a crime of violence for someone who failed to register. And so it's possible that subsection D might be a sex offense that a false statement could relate to, but failure to register under A and B are not sex offenses that could trigger the enhancement.
Do we even need to go to Appendix A if we look at the statute itself?
Yes, Your
Kind
Honor.
of where my question is, because the statute says if the matter, meaning the matter within the jurisdiction of here, the executive, if the matter relates to an offense under Chapter 109B, then you get 8 years.
You can get up to 8 years.
Yeah.
So it's not, it's a enhanced maximum, not
You
mandatory
are so
minimum.
right. Up to 8 years. It's
Right.
not 8 years.
Right.
So if
Right.
the matter relates to an offense under 109B,
Yep. Yeah.
not more than 8 years. So there, the statute takes us right to 109B, which is failure to register.
Right. So the appendix language does not track the language of the enhancement. 1001A says an offense, but in Appendix A, it says sex offenses. The clear difference between the two phrases requires that there be a sex offense under those cited chapters. And in response to Judge St. Eve's question, I was proffering that potentially under 2250D, not A or B, there could be a sex offense for a false statement to relate to. But under A and B, there's no sex offense, and therefore, even if the 8-year maximum might apply, you don't go to 2J1.2. You stay within fraud and deceit under 2B1.1. For that reason, because there is no sex offense to relate to, Mr. Cohen's false statement does not relate to a sex offense, and the district court erred in selecting 2J1.2.
Why, you started out by talking about definitions in other places. Why would those matter when Appendix A and 2J1.2 supply their own definition? Why do we need to go outside of there?
I would disagree that 2J1.2 provides a definition. The phrase sex offenses is not defined in 2J1.2 or in Appendix A. And so in trying to figure out what that means, because of the discrepancy between the language in 2J1.2 and in 1001A, I looked for other federal definitions of sex offenses, including the definition under SORNA, which was passed in the same 2006 bill as 1001A. And SORNA's definition does not include failure to register under 2250A or B. I also looked at sentencing guidelines provisions, and in every single provision, sex offenses does not cover failure to register. In fact, the commission actually amended 5D 1.2 in response to a circuit split because some courts were holding that failure to register was a sex offense, and the commission explicitly changed 5D 1.2 to make clear that it is not a sex offense. And so that's where the different definitions come from to interpret 2J 1.2.
Let me take you back to 2J 1.2. And apologies if you think you've covered this already. But tell me why this reading is wrong. If it says, because the matter relates to sex offenses under 18 U.S.C. 1591, or because the matter relates to chapters 101, 109A, 109B.
Yeah.
If the matter modifies both relates to sex offenses under 1591, and then separately, the matter relates to chapter 109B, that avoids the word sex offense, and it just says the matter relates to 109B, and then here, the matter relates to 109B. So tell me why that would be an incorrect reading of the language in 2J 1.2.
Sure. I don't think that's the most natural reading. Usually when there's a modifier at the beginning of a list of clauses, the modifier would apply to each of them. But even if you were to interpret it that way, there's another reason, which is that there's no scienter included in the information. And in order for the enhancement to apply, the information has to have an acknowledgement and factual basis to show that the defendant had knowledge of the matter under investigation. And the information simply doesn't say anything about Mr. Cohen knowing the matter under investigation. And at the stage of guideline selection, you're only allowed to look at the information. The Supreme Court has repeatedly said that for sentencing enhancements, a scienter requirement must apply, even if it's not explicit in the statute. And in the few decisions that have interpreted the enhancement.
Why, I don't understand your scienter argument. I'm looking at the information here. It charges him with knowingly and willfully making a material false statement in a matter relating to an offense under Chapter 109B.
So it charges him with knowingly and willfully making a material false, fictitious, or fraudulent statement and representation. So there's scienter as to the false statement, which would simply be the traditional offense under 1001, which carries a 5-year maximum. My point is that you must also know the matter under investigation in order for the enhanced maximum to apply. The information does not say that Mr. Cohen knew the matter under investigation, and so it can only support the 5-year maximum. And if only the 5-year maximum is supported by the information, then you can't go to 2J 1.2.
Why doesn't his plea agreement waive that particular argument with regard to the sufficiency of the information?
Because 1B 1.2 doesn't permit consideration of the plea agreement unless there's an explicit stipulation that permits that. There is no such stipulation, and the government never argued there was a stipulation. So at this early stage of guideline analysis, you simply can't look at the plea. I'd like to reserve the rest of my time for rebuttal.
Okay, thank you. Mr. Hayes?
May it please the court this morning, Brian Hayes on behalf of the United States. The district court did not err in using 2J 2.1 to compute the defendant's offense level here. Appendix A, as the court has observed this morning, says that 2J 2.1 applies if the 8-year maximum applies because the matter relates to sex offenses under enumerated provisions, which include Chapter 109B. The defendant acknowledged in the district court in his plea agreement that all those things were met, that the 8-year statutory maximum applied, that 2J 2.1.2 applied, that he knew that the matter related to a violation under Chapter 109B, and that the offense, not just that 2J2.1 applied, but that a 4-level upward adjustment applied because the matter related to a sex offense under Chapter 109B.
But how persuasive is that argument when the plea agreement specifically says that defendants can correct errors in sentencing guidelines or interpretation of them prior to sentencing?
Judge, you're right that the plea agreements do permit the parties to address errors in interpretation, application, in order to avoid these sorts of mistakes in validating plea agreements. That's the primary purpose of paragraph 10 of the plea agreements. But I think this court has said in U.S. v. Martinez, I think that was 122, 521 Fed Third, we cited it in our brief, that there was a point where that concept could be stretched too far. And the government was, frankly taken to task a little bit for not staking out a stronger position as to why isn't the government holding the defendant to his admissions here. Fortunately, this is not a case, I think, where, if you'll excuse me coining a phrase, the panel is going to have to struggle with where does the Martinez line, if you will, get drawn, because I think under any standard here, whether it's de novo review, whether it's plain error, whether it was waived, the district court did not err because based upon the facts that were presented and the admissions made, this guideline was properly applied. Appendix A states that applies to matters that relate to Chapter 109B, and that's really all the court needed to find. And I think the defendant's arguments are unconvincing in that regard.
Mr. Hayes, what do you make of the addition of the word sex and sex offenses in the guidelines? Because the statute doesn't have it, right?
That's right.
And as far as I can tell, looking at all the various statutes that come after it, they all seem to involve, the same types of offenses. I mean, putting 102B to the side, they're all very explicitly sex offenses, whether it's child sex offenses or trafficking or what have you. In a way, it just seems like that term is a bit redundant or unnecessary. But then again, we are to try to give as much meaning to all the words as possible when interpreting text. And so I'm wondering, why do you think that's there?
If you look at historically what was in Appendix A as to 1001, what it said before was that it applied when the matters relate to international and domestic terrorism, whereas the statute refers to some specific provisions as to those offenses. In the guideline, it did not at that time. And so when they drop in this part about 1001 with the enactment of after the enactment of the Adam Walsh Act, I think rather than going from international and domestic terrorism and offenses under da-da-da, it sort of made sense to drop sex offenses in there just as sort of a prefatory descriptor of, okay, we're changing subjects now, and here's what we're talking about. So I think that adequately explains it. And I think that's particularly persuasive when you look at the legislative history and the commission commentary relating to Amendment 701, where they explain what they were doing here. So that's one reason why I think the defense's arguments against the district court's application are not convincing, because it would effectively render 109B a nullity in Appendix A. And then I think even if you do accept the defense's position that we need to sort of take sex offenses out separately from its context and sort of give it some substantive meaning, the result is still the same, because the application note says it applies if the matter relates to sex offenses. And as this court knows, relates to has one of the most broadest meanings you can imagine when you're conducting statutory interpretation. And in this sense, a sex offender who's lying about the registration address of another sex offender, and a registration requirement that stems from a sex offense, this does relate to sex offenses in that sort of natural understanding of the term even, and also in the broad way it's understood in federal law, even criminal law. So the government believes that the district court's use of 2J1.2 was correct, and unless there are further questions,
I do. I would like you to respond to Mr. Cohen's argument about the scienter requirement in the information in the statute, specifically the idea that the government had to allege in the information that he knew the matter being investigated.
Judge, I think that in the beginning of the allegations, when it said the defendant did these things knowingly and willfully, that carries into that that new, I guess I would call it an additional factor, given that the 8-year statutory max is going to apply. It's sort of the enhanced offense, but I still think you can read that knowingly and willfully at the beginning to cover both premises. I think certainly standing here now, perhaps we would do that different and make sure that was more clear, but certainly in the plea agreement, and I think in the information, which provided a lot of context for the case, that seemed implicit to me.
Seems implicit?
I'm sorry.
Okay.
If there are no further questions, then I will conclude. Thank you.
Thank you. Mr. Picard.
Your Honors, in response to your question about the best way to interpret whether 1591 could be set off from the rest, I would point Your Honors to the exact language where there's no comma between sex offenses and then under 18 U.S.C. 1591 or chapters. They're all part of the same phrase. So grammatically, it wouldn't make sense to have sex offenses only apply to one part without a comma splice between them. Additionally, Appellee said that the knowing and willfully part of the scienter was implicit in the plea agreement. I'd like to point Your Honors to a Ninth Circuit decision called Green that speaks to the requirements of factual basis in an information. The citation is, I can provide that in, oh, here it is, 137 Federal Reporter 4th, 1056. It says that has to unambiguously include the factual basis, and there's no unambiguous inclusion of that in the information. And finally, to end, the fact that the plea agreement did not have this information is fatal because the court cannot consider the plea agreement, just the information. Thank you, Your Honors.
Thank you. Thanks to both counsel. The court will take the case under advisement. Our final case for oral argument this morning is appeal number 24-2504. Excuse me, Caraba versus Paul Revere Life Insurance Company. Good morning, Mr. Dabowski.
Good morning, Your Honor, and may it please the court. My name is Mark Dabowski. I represent Dr. Brian Caraba in this matter. The issue before this court is whether Paul Revere Life Insurance Company can be allowed to escape its contractual obligations by applying a self-serving interpretation of the undefined term other gainful occupation in Dr. Caraba's policy. The term other gainful occupation is susceptible to multiple meanings. This is demonstrated by the cases that we cited. It's demonstrated by Paul Revere's own customer claim manual, which uses a specific definition with respect to long-term disability insurance, but there is no definition in this policy. Now, the customer care manual does have a separate section for individual disability insurance policies that lack a definition of the term other gainful occupation. The section in the customer care manual says that a number of factors will be employed, but one that was clearly omitted in this case, and which was a fatal error by the insurance company, is that the claimant's education, work experience, and prior earnings had to be taken into consideration. Now, we don't argue that there has to be a specific percentage threshold or a particular dollar amount, the ambiguity is still present. And where there is an ambiguity, there is a long-standing legal doctrine known as contra proferendum that has been in existence since the 1600s. It was incorporated in United States jurisdiction by the Supreme Court in 1923. This court has decided numerous cases where it has applied the doctrine of contra proferendum. And where that doctrine applies, an ambiguity must be construed against the insurance company and must be construed in a manner most favorable to the insured.
If we agree with the district court that the policy does not require consideration of your client's pre-disability salary, are there any disputed issues of fact left?
There wouldn't be, but that determination was error.
I understand your argument. I want to make sure I understand the full scope of it. So if we would agree with the district court on that issue, that you did not have to, the insurance company did not have to consider his pre-disability salary, you would agree that your client cannot prevail then?
That would be somewhat obvious, but as we've maintained, there was clear error in that determination. The court based that determination on its citation of the Ghazi versus Fiserv case, which is an entirely different kind of insurance policy as the one that Dr. Caraba purchased. Ghazi versus Fiserv, using the distinction in the Hammond case from this court, would be classified as a general disability policy, while Dr. Caraba's policy would be classified as an occupational policy. And that determination does not square with Paul Revere's own internal documentation that the age, education, experience, and prior salary has to be a factor that's taken into consideration.
Mr. Dubowski, can you educate me on what role the outline of coverage has when the insured and the insurer are kind of communicating what the terms of a policy would be?
Absolutely none. The outline says explicitly that it is not the policy, and the terms of the policy.
I understand it's not the policy. I'm wondering, is that a document that is exchanged between the insurer and the insured as part of the negotiations, discussions before the policy is finalized and executed?
I believe it was. But there too, the outline of coverage says meaningful occupation. And you can't disambiguate an ambiguous term with another ambiguous term. Meaningful salary or meaningful earnings.
And with regard to the doctrine of contra proferendum, I wonder what your view is on when that doctrine is triggered. Is it triggered initially if we look at the four corners of a policy and think that a term is ambiguous? Or is it triggered later on after we do a more fulsome inquiry to look at any sort of relevant extrinsic evidence and see if we can come to some sort of construction with regard to the term?
I think it would be both, Your Honor, because
well, I think it can't be both because
let me explain if I can. So in the first instance, looking at the policy itself, other reasonable gainful occupation, what does that mean? And the industry standard suggests that it means 60% of your prior earnings. Case law going back to the 1920s Eureka decision from California says that station in life has to be considered. Case after case has cited other policies that define the meaning of that term to be the equivalent of 60% of your prior salary if you're not working, 80% if you are working. So for the insurance company in this case to take the position that it is the median salary for all wage earners in the state of Illinois is something that's just totally made up. Now, we cited two cases
Well, I'm not really sure that, kind of taking you back to my question, I'm not sure that really addresses my question, which is, I'm trying to decide whether it's the doctrine of contra preferendum is a doctrine of last resort, that is, after we exhaust every kind of tool that we have in constructing or interpreting a term of a contract, or whether it's a doctrine that kicks in if we can't figure out what a term is, if we determine a term is ambiguous based upon the intrinsic evidence, the four corners of the contract.
I think it would be the latter, Your Honor. And I was going to say that we cited two cases for the bad faith argument that apply here as well. The first case was from the Ninth Circuit, the Amadeo versus Principal Life case. And the court said something very important there. The court said that an insurer cannot escape bad faith liability by adopting an interpretation of its policy grounded only in the subjective perceptions of its unguided claim adjusters. We maintain that that's exactly what Paul Revere did in this matter. And the other case that we cited was Wolf versus Prudential Insurance from the 10th Circuit. And in that case, and I quote, "Insurers are obviously well aware of this familiar rule," referring to the doctrine of contra proferentum, "but Prudential's argument would allow them to ignore it with impunity. Under Prudential's argument, an insurer could intentionally insert an ambiguous term into a policy and continually deny coverage based on that term, despite contrary court decisions or its own doubts about the meaning of that term. The risk of drafting improperly should be falling on Paul Revere in this case and not on Dr. Caraba. That's the whole point of the contra proferentum rule, that it shifts the risk to the party who drafted the contract and could have prevented the loss. Had Paul Revere incorporated a definition of other reasonable gainful occupation consistent with its later interpretation, I wouldn't be standing here today. They didn't do that, and for that reason, this court must reverse the district court.
Thank you, Mr. Dabowski. Ms. Herring? Good morning.
Good morning. May it please the court, Jacqueline Herring on behalf of the Paul Revere Life Insurance Company. Under this particular policy, no disability benefits are payable when Dr. Caraba continues to work in any gainful occupation.
What guidance do insured parties receive when they sign up for these parties about these policies about how Paul Revere is going to calculate gainful occupation?
Well, I think as Judge Lee pointed out and as the district court pointed out, there's the number one in the application, he can choose different coverages. This is the coverage he chose. He did not choose coverage that was own occupation coverage.
I asked what guidance do parties receive when they sign up for these policies about how Paul Revere is going to define or calculate other gainful occupation?
I don't know the answer to that question, Your Honor, other than what's in the outline of coverage. And the thing is, there's all this discussion of ambiguity, but there is no ambiguity unless there are two competing definitions. Plaintiff has never offered a competing definition. The parties agree essentially on the definition that gainful needs to be some sort of substantial income. And that flexibility isn't an ambiguity, it's a flexibility that this court has recognized, the O'Reilly case that we cited, that said if you impose a specific percentage, that just doesn't make sense and leads to absurd results in some cases. Same sort of issue in the McFarland case, when the debate was, well, how many duties do you have to be unable to perform before you're unable to perform your occupation? And it's not a set amount because we need to have flexibility. Sometimes one, sometimes more. So somebody making $1 million, 60% of their income, 500, if they're just under that at the 599, you ask anybody the reasonable and ordinary definition of that term, $599,000 is absolutely going to be a gainful occupation, but under the 60%, which is the only thing that plaintiff has ever suggested is that it must be a 60% guideline. That's adding something to the contract that isn't there. The contract does allow flexibility. This court has endorsed the concept of those flexible terms leading back to the McFarland decision, as well as discussed in O'Reilly.
So what's gainful employment would vary depending upon the underlying occupation. Is that fair? What is a gainful occupation would vary. If you're a dentist versus a cashier versus a stockbroker.
I think that all of those factors would play into, and that's again why there needs to be a flexible standard. And in individual coverage, there's also this sort of, well, this is what we do in group coverage, so we must do that in individual coverage. And those are two entirely different situations. Somebody in group coverage is paying a premium to get 60% of their income insured. Dr. Caraba didn't pay to have a specific percentage of his income insured. He paid to insure $37,000 a year. That's it. So to suggest that $70,000 isn't gainful when he only insured $37,000 also doesn't make sense.
Is there anything to what I take to be Dr. Caraba's concern that having it undefined could lead Paul Revere to consistently say, well, okay, the minimum Social Security earnings qualify as gainful, gainful earnings qualify as gainful occupation. So that's that, and would that be misleading to someone who purchases what's titled here a business executive policy? Anything to that?
I don't think that would occur, but again, the issue is this contract ambiguous? And a term not being defined doesn't make a contract ambiguous.
Well, I guess, to Judge Jackson and Tim's point, if I'm the insured, how would I know? Like when I'm trying to order my life and I have this policy and, I presumably can work in certain occupations, certain jobs, and let's say I have a choice of jobs, but I want to make sure that that I'm not doing anything that would somehow invalidate this insurance policy. How would I go, practically speaking, making that determination?
Well, I think you could ask the question, number one, and that's where things like the outline of coverage would come in. We have situations that I've seen where someone says...
So I could actually call Paul Revere and say, hey, I'm thinking about doing this. Will that disqualify me from the coverage?
Yes, or the agent you worked with to get the coverage, depending upon at what stage you are. And we see that regularly, particularly with someone who wants to know, how are you defining my own occupation? I'm in a very unique specialty. I'm a heart surgeon. Would you consider that my own occupation? And we see specialty letters that are issued that respond to that and help with explaining how that is. But again, this isn't really about what the insurer did or didn't do. This is a breach of contract action that's in court. And the issue is, was the contract breached by not paying him benefits under the terms of this policy? And it wasn't. The plain and ordinary definition that we see in the dictionaries that we saw in other case law is any occupation from which the insured can earn a reasonably substantial income rising to the dignity of an income or livelihood. He was earning $70,000. That's 20% more than the average Illinois citizen.
Is it kind of you know it when you see it?
I don't know so much you know it when you see it as there's a balance of factors. And again, that type of flexibility is allowed in disability coverage. It doesn't make a term ambiguous. And the McFarland decision was clear on that. Other courts that have considered this same language have found it not ambiguous. So there is no court that has said this language is ambiguous. And again, an ambiguity requires competing reasonable interpretations. Plaintiff has not offered any competing reasonable interpretation other than to say we need to append onto the policy a 60% requirement. That's not a reasonable interpretation of gainful. That's a, here's the only factor I want you to consider in deciding whether it is gainful.
Does the insurance company consider the amount of the benefit in trying to determine what is gainful employment in a particular case? So let's say here, if he had insured $100,000 worth, right, of benefits, right, that is, as opposed to $37,000, is that something that would come that Paul Revere would take into consideration in determining whether or not $60,000 is gainful?
And unfortunately, I think the answer I need to give is it depends, because again, it's a flexible analysis. Just like in McFarland, maybe one duty makes you disabled, whereas for somebody else, being unable to do 65% of his duties, he's not disabled. So it really does become disability is a fact-based decision. The same way you can't say because somebody has, a lumbar degenerative disc disease, they're disabled. Well, it depends. What's the impact of that?
You started out by mentioning that he had different choices and policies that he could purchase.
Yes.
And you seem to say that one of the choices he had was he could have actually purchased a policy that insured him 60% of what he was making at that time. Is that correct? Did I hear you correctly?
Yes, that's the AB form that's in that outline of coverage where you can choose what percentage you want. And it's not so much that you're insuring a particular percent, it's that any occupation becomes defined by the percent that you choose. Yes, because the percentage of income, there's underwriting factors that are a little more dense than I can talk about right now that would determine the actual percentage of your income that you could insure. But that would allow for a specific percentage to be guaranteed to you. And again, that becomes more the situation of the functional analysis. All of the group coverage cases that are cited in plaintiff's brief are dealing with an entirely different issue. These are people who are not working. And the question is, what functional floor are we going to set for them? What occupations are we going to look at that are appropriate for those people so that we can determine a functional analysis of whether they're able to work. In this case, he is working. And the only question is whether that $70,000 he is earning that exceeds every marker, including what he earned from his own dental practice, whether that is a gainful occupation. Facts are undisputed, and the district court should be affirmed.
Thank you, Ms. Herring. Mr. Jabowski, you have about a minute left.
I think counsel overstates her argument and also relies on hypotheticals that are not present here. This is the policy that Dr. Caraba purchased. This is the policy that did not have a definition of gainful occupation. This is the policy that Paul Revere itself says in their benefit claim manual that they must take into consideration education, training, experience, and income. By using the median income for all wage earners, they failed to do that. And this policy is ambiguous. The doctrine of contra pro forentum applies, and this court should reverse the lower court. Thank you.
Thank you, Mr. Jabowski. Thanks to both counsel. The court will take the case under advisement, and that concludes our oral arguments for today.